Colleagues, I rise as an institutionalist, not an activist. But I do feel it's important to put a couple of points to this body as we consider the motion before us. I'd like to begin by recalling a speech given from this very seat by Ian Shugart in June of 2003, where he invited us to anticipate the future with him. And he said, in this Parliament, we have witnessed a sea change in the composition of the upper house. If the present government is re-elected, and they ultimately were, we can expect further evolution of the Senate. The further we get from a party-based Senate, the more entrenched will be the idea of independence and freedom of action. Taken too far, we could find ourselves with many senators effectively setting themselves up as a de facto opposition to the government. We could be left with a frequent or perpetual standoff between the two chambers as more and more independent senators claim a right to block legislation coming from the elected chamber. Alternatively, notwithstanding the current attention being given to foreign interference, I'm convinced that our democratic institutions and processes are healthy enough to give us a different government. Should that be the case, some senators may feel it is their right and obligation to oppose any legislation from the other place if it reflects a philosophical perspectives with which they disagree. Given the numbers that can be projected, this could be a recipe for legislative paralysis. To be blunt, either scenario creates the possibility that the institution could be at risk of acting undemocratically, ironically by allowing tightly held principle to trump constitutional convention and deference to the will of the elected chamber. In either situation, we have the seeds of a constitutional crisis. He ends with saying, we have benefited from restraint in this country, and in these times, we need it again. In April of 2018, I tabled a document with colleagues entitled Complementarity of the Constitutional Role of the Senate of Canada. And I want to briefly recall some of the points made in the subheading chapter on labeled in the Senate, self-restraint is a constitutional watchword. It would be misguided to equate the Senate's formal powers under the Constitution with the Senate's role in our constitutional architecture. This is a false equivalency. The Senate's power is not defined by the institution. They exist to serve it in the appropriate discharge of its role as Canada's complementary upper chamber. To be clear, the issue to be addressed is not how far the Senate can go in its relationship with House Commons, for its powers allow it to go farther than any other unelected legislative body in the democratic world. Rather, the question is how far the Senate should go when it challenges the will of the elected chamber. And I continued saying the Senate's constitutional role is not strictly defined by the constitutional powers. In fact, the method of selecting senators, choosing senators for the Senate in 1867 is a much more accurate indicator of the Senate's intended functions. Senators were appointed precisely because the founders believed that without a democratic mandate, senators would have the good sense to thwart the will of the House of Commons in only rare and exceptional circumstances. It is crucial in this time of change in the Senate to recognize the subtlety of role that the founders of the Confederation envisaged for the Senate. They sought an upper house with enough power to act as a legal safety valve against tyranny of the majority. The bottom line is that the Confederation provided an opportunity to return to the relative safety of an appointed upper body that worked as a complement to the elected lower house instead of as a rival. The Supreme Court confirmed as much in 2014 when it decided that implementing consultative elections for the Senate would require a constitutional amendment involving substantial provincial buy-in. Having combed through numerous pleadings, historical materials, doctrine, and expert evidence, the court unanimously opined that under the constitutional architecture adopted by the founders, our upper chamber was specifically designed to exercise voluntary self-restraint in its relations with the House of Commons. Consultative elections for Senate seats would have fundamentally upset this balance. The court was crystal clear, and I quote the court judgment. The choice of executive appointment for senators was also intended to ensure that the Senate would be a complementary legislative body rather than a perennial rival of the House of Commons in the legislative process. Appointed senators would not have a popular mandate. They would not have the expectation of legitimacy that stems from popular election. This would ensure that they would confine themselves to their role as a body mainly conducting legislative review rather than co-equal of the House of Commons. The Supreme Court could hardly have been more explicit. The constitutional design of an appointed Senate reflects the unequivocal intent of the founders to ensure that the democratically elected House of Commons work would be complemented by an appointed chambers of sober second thought. As Professor Smith notes, rather than compete, the upper house completes the work of the lower house. And in this context, it was indicated that senators were intended to study government legislation by applying their sage and independent judgment while maintaining a healthy level of self-restraint in challenging legislation that had been passed by the House of Commons. Hence, by constitutional design, the Senate's natural bias should be self-restraint, or as the philosopher Larry David might have advised, curb your enthusiasm. But what is appropriate self-restraint? The short answer is it's complicated. And here we are in a complicated situation. I want to say a few words about where we are. I, at least as an institutionalist, will not give in to the cynicism I've heard even in speeches today about the intent. I don't believe that the House of Commons is trying to pull the wool over our eyes. I don't believe that there's a cynical adding of this measure to a bill to prevent us from dealing with the matter contained in the Section 4 because it's a money bill. I believe it honestly was the early opportunity for the unanimous view of a minority parliament, which understood that it had avoided the vehicle, or had not found the vehicle of dealing with it in the previous minority parliaments, to move forward. And I believe that they probably are as surprised as I am that we have had the kind of debate we have had on this measure over the last number of weeks. So if you're an institutionalist, I think you have to take the other chamber at its word and believe that it is proceeding in good faith. This amendment, in my view, is overreach. It is overreach with respect to the role of the Senate, and it is born of a cynicism I will not share, and I do not believe this institution deserves. In the second reading speeches, I particularly liked Senator Deacon's speech because it was broadly informed on the policy issues which have animated the debate in the LCJC, as well as in this chamber for that second reading speech and third. I went up to him afterwards and I said it was a terrific speech, and if your intent is to educate us and hopefully educate a broader public, including perhaps the other chamber, on the issues around PIPEDA, I'm all for it. And in fact, I would be the first to propose a motion that a special committee of the Senate, not just legal affairs, be constituted to do that. I was around when PIPEDA, I was the deputy minister responsible for PIPEDA 25 years ago. And it is not as easy as any of the speeches here have suggested. It is a very complicated process of trade-offs and expectations. And the technology around information itself has changed over 25 years, which is why Canada went from being a leader 25 years ago to being a laggard today. And I always am trying to look for constructive opportunities for the Senate to move on issues that it feels important about that are not obstructive of the will of the other place. Colleagues, I very much urge us not to pass this amendment, or frankly any other, with respect to this measure, but do not give up the discussion and the debate and in an informed way move forward so that the environment for legislative action can be more mature than it has been over the last 3 years. So while I welcome the reference to the Legal Affairs Committee for the Part 4, I do not welcome the amendments placed before us. I believe that it is important for us to have, particularly in a minority parliament, our third in a row, by the way, which is a new government. I know some people will think this is the 10th year of a Liberal government. It's the first year of a Carney government. and the relationship that it forms of what an independent Senate should be will be shaped by how the independent Senate works. And the biggest threat to an independent Senate, frankly, are independent senators in our behavior, in our negotiation, and in our relationship with the other chamber. And I, for one, believe in the model that we constituted now almost 10 years ago, and would urge you to think of the longer term of how we can be an instructive partner in the legislative dialogue between the other house and our chamber. So for that reason, colleagues, I urge you to reflect for a moment, breathe deeply, and say what is in the interest of the institution in the longer term, and please, let's move on.
Sénatrice Clément, vous avez une question?
Senator Clément, you have a question?
Harder?
Of course.
Sénatrice Clément.
Thank you, Senator Harder, for your speech. And I want to respond and then ask you a question as an institutionalist. So my first response is around Senator Shugart, who sat in your seat. And I was here sitting in that seat listening to that speech about restraint. And he gave me 30 minutes of time after that speech so that we could speak about it, because I found it to be remarkable. And in that conversation, you know, we agreed to disagree, but I found it remarkable at that time of his life that he would grant me that time so that we could talk about it. So I appreciate you raising that. I want to also respond to the cynicism piece. I certainly make this amendment with not that. I will get to a question about him as an institutionalist, but the cynicism piece is not there. For me, it's really about the trust piece and what it feels like to knock on doors and what it feels like to have trust between federal political parties and electors. So it's from a very personal place and not a place of cynicism. When you say that you speak as an institutionalist, and you stood up and you said, I'm not an activist, I'm an institutionalist, I want your reaction to this. Institutions have to change. This institution is different than what it looked like 10 years ago, 20 years ago. And so there has to be built-in change and evolution. The former Prime Minister made that a focus for this chamber. And so as an institutionalist, do you not recognize that there has to be some evolution and that there already is? We're there, we're in that moment.
Senator Harder.
I very much welcome that question, because while I say I'm an institutionalist, I hope that doesn't mean I'm a regressive preservative. Look, I came here 10 years ago next month and was asked to provide some leadership to the notion of a less partisan, more independent Senate. And the appointment process was put in place. When I arrived, it was rather lonely looking across a very large group opposite. Senator Carignan was the leader at the time, and we were building new practices as we went. I remember the first budget bill. Senator Carignan came to me and he said, "How many votes do you have?" And I said, "All I know is I've got 3. And he said, "You've got to be kidding. I don't know." And I was glad to see that the bill passed because of the willingness of the chamber to accept its role. There is practiced restraint. It's not advertised, but it was practiced restraint. We had amendments to the standing orders that were sessional orders to accommodate the change. So, Senator, I think that this chamber has evolved tremendously, not just because of the independent senators that were appointed, but those who were here before. They adapted somewhat less enthusiastically, perhaps, than some, to this evolved Senate. What I want you to know, though, there is a risk of overplay. And that is the risk I would like you to reflect on, because I think that the reaction of a new government, a minority government, a government that is under tremendous pressures in the circumstances of the moment, would not welcome the upset that some of the senators would have on this and other pieces of legislation.
Thank you. Thank you, Senator. There was another senator that I wanted to ask a question, but the time allowed is expired.